pleasure today to be at the LSB and Commissioner and to welcome Russell Daly, who's the Executive Director of Complaints and Intervention. So welcome, Russell.
Thank you very much.
A few questions that I propose that we put to you concerning your role firstly here at the LSB. What exactly do you do?
Well, my area looks after the complaints that are received by the Commissioner and the handling of those, which might be from dispute resolution through to a prosecution ultimately. And also looking after some of the board responsibilities in relation to oversight of trust accounts, unqualified practice investigations and other interventions into law firms.
Okay, so our primary focus today of course is on the new legislation introduced mid last year. What are the major changes you think have been introduced as a result of the uniform law?
Well, in relation to our office, it gives the Commissioner some extra powers in relation to complaints that the Commissioner receives. We can now make determinations in certain cases without having to send the parties off to VCAT if the matter can't be dealt with in-house. It also sets up a new costs regime requiring more informed consent from a client in relation to the cost incurred in a matter. And in relation to the board, it gives the board some extra tools to deal with compliance auditing in relation to non-incorporated legal practices.
Yeah, so that's quite a broad sphere. I suppose a lot of the focus to date has been on the new cost regime.
It has.
But one of the points that we need to get to is this question of intervention. I notice in your title you're the Director of Complaints and Intervention, so there seems to be an escalating ability to intervene. Could you speak to that? How does the LSB view that?
I can. Well, I mean, obviously if anything comes to our attention, we try and deal with it as quickly and as appropriately as we can. And that involves minimal intervention most of the time, trying to sort out a problem or try and talk to the firm or the practitioner to try and help them fix it themselves. We have a number of tools available to us to do that. At the pointy end, however, if law practice fails, if a practitioner is incapacitated or even if they're arrested for a criminal offence, the board might be required to put in place some other form of more formal intervention to deal with the practice so that the consumers aren't disadvantaged.
Okay, so I mentioned the fact that there have been some concerns, I think, in the legal profession generally since the introduction of the uniform law. What sort of come through on your radar that the legal profession has been upset about or concerned about or been questioning mainly?
Well, I suppose the two big areas have been in relation to cost disclosure and what the changed requirements mean for people there. As I said, informed consent is something that is new in the legislation, and trying to work out what that means for not only for clients but for the firms themselves has been a big issue. And also in relation to the expanded compliance auditing regime, previously under the Legal Profession Act, the board had powers to conduct a compliance audit in relation to all incorporated legal practices.
That's right.
That power has now been extended to all legal practices. However, also there's been put in place some threshold question that we have to address. There has to be some form of reasonable ground before the board chooses to exercise that tool.
So if we can turn now to the specific requirements under the new regime, if I can call it that, for appropriate management and supervisory processes or systems that's mentioned, I think at 257 in the Act. How does the LSB view those requirements?
Well, after conducting a compliance audit, the board can issue a management systems direction, which is a more formal response, I suppose, to any problems that might be identified during the compliance auditing. That isn't defined in the legislation, but there's a great body of literature and work behind that that informs the 10 principles and the associated detail that goes with that, which really, in our view, just reflect best practice.
Yes, it's not just a question of compliance. Most of them, if you review them carefully, really reflect good business practice as well as good compliance practice.
And they not only would help deal with avoiding complaints in the future, we would hope, if you have in place good practices. But if a complaint ever does come to our attention in relation to something, then having those good practices in place will help you respond to the regulator and to be able to respond appropriately to any concerns raised by a client. It's only good sense.
Indeed. And what about the history so far? I know it's been a relatively short period. Have there been any management system directions issued yet here in Victoria?
There haven't been any management system directions in a formal sense issued at all, no. Since the new regime has come into place, we have visited a number of incorporated legal practices and non-incorporated legal practices, looking at them through the new powers. But really it's been a continuation of the program we had in place under the previous legislation, where we looked at incorporated legal practices with the same powers.
Okay. And just looking across the broad perspective of issues that come to your attention specifically, that attract your attention, what are the major sort of categories of circumstances that cause you to respond or potentially intervene?
Well, ordinarily it's a complaint history, and sometimes it'll be a number of complaints that reveal over a period of time a sort of low-level problem that's systemic in nature, and it might be in relation to problems with cost disclosure or communication or other service type issues, where that leads, in our view, to the firm attracting a lot of complaints. Now, we obviously don't want to see that. We don't want to have to keep dealing with the same complaint over and over again. So it gives us an opportunity to engage with the firm, see where they might be letting themselves down, and try and work through with them some strategy to try and address those sorts of problems. We go in there in a very collaborative way. With the Law Institute, we partner up with an auditor from there as well.
Mm-hmm.
Go in there, and invariably our experience has been that after the audit has taken place, that the firm are very happy with the way it's been done.
Okay, so if I understand you correctly, one of the common scenarios is that there's a complaint from a member of the public, say a client of a firm. You contact the firm concerned, inquire about the circumstances. The problem may be a systemic problem which might require some attention to their management systems, but at the moment you haven't issued any sort of management system directions as such, but that's a power that you could exercise in the event that, I guess, the conciliatory approach that you've outlined wasn't effective.
That's right, but we do provide them with a report on what we find at the end of the auditing process.
Okay.
And that may, and often does, contain some suggestions, usually which have been discussed and usually agreed with the firm beforehand. And we do follow up on that, and most people have been very grateful for the insight, I suppose, that's been provided and for the guidance that they've received. And none of those have led to any situation where we've had to take a more formal approach.
Okay, so one final question perhaps before I let you off the hook, Russell, and that's the question of additional regulatory requirement or initiatives on behalf of the VLSB. Is there anything in the pipeline that we can expect to see in the foreseeable future?
Well, I don't think there'll be amendments left, right and centre to the legislation, but obviously it is always under review. It's a new scheme and it will need refinement. I understand that the uniform bodies who are capable of issuing guidelines and rules in relation to the way the scheme is administered are currently considering and have sought some comment in relation to refining those guidelines in relation to the costs estimate issue, and also in relation to the consequences for a cost agreement where no disclosure is given, where a cost agreement could be voided. So those guidelines that are being considered at the moment are aimed to try and refine those requirements and, promote greater understanding within the profession of what it might mean, and also some guidance on how to avoid falling into some of those traps. But obviously whatever the uniform bodies issue by way of guidelines, we're bound to follow.
Okay. All right, well thank you very much, Russell, and thanks for your time.
Thank you.
We'll look forward to seeing you no doubt at various venues promoting or discussing or publicising the issues that we've discussed today.
It's always a pleasure.
Okay, cheers.
Thank you.